Appraisal of REO and Foreclosure Properties, Chapter 3, the Foreclosure Process, page 5, Trust Deed.
Trust deed. A trust deed or deed of trust is a legal instrument similar to a mortgage which, when executed and delivered, conveys or transfers property title to a trustee. A trust deed may be defined as a three-party security instrument conveying the legal title to real property as security for the repayment of a loan. The three parties specified in a deed of trust are the borrower, lender, and trustee. In deeds of trust or mortgages where a power of sale exists, the power given to the lender to sell the property may be executed by the lender or the lender's representative, typically referred to as the trustee. Regulations for this type of foreclosure process are outlined in the Power of Sale Foreclosure Guidelines established by state laws. End of page. Power of Sale Foreclosure Guidelines. If the deed of trust or mortgage contains a power of sale clause and specifies the time, place, and terms of sale, then the specified procedure must be followed. Otherwise, the non-judicial power of sale foreclosure is carried out as follows. Generally speaking, a notice of sale must be 1. Recorded in the county where the property is located at least 14 days prior to the sale. 2. Mailed by certified mail, return receipt requested, to the borrower at least 20 days before the sale. 3. Posted on the property itself at least 20 days before the sale. And 4. Posted in 1 public place in the county where the property is to be sold. The notice of sale must contain the time and location of the foreclosure sale, as well as the property address, the trustee's name, address, and phone number, and a statement that the property will be sold at auction. The borrower has until 5 days before the foreclosure sale to cure the default and stop the process. The sale may be held on any business day between the hours of 9 a.m. and 5 p.m. and must take place at the location specified in the notice of sale. The trustee may require proof of the bidder's ability to pay their full bid amount. Anyone may bid at the sale, which must be made at public auction to the highest bidder. If necessary, the sale may be postponed by announcement at the time and location of the original foreclosure sale. Lenders may not seek a deficiency judgment after a non-judicial foreclosure sale and the borrower has no rights of redemption. In California, there is no right of redemption in this type of foreclosure. However, each state has its own specific rules governing these types of action. Appraisers are advised to understand what is possible in his/her state. The implied advantage of the non-judicial foreclosure is that it does not require the cost of time, effort, and money to file a lawsuit. It is usually true that the process takes much less time than a judicial foreclosure. End of page. Non-judicial foreclosure timeline. The website of JT Legal Group provides an overview of the non-judicial foreclosure process in California. It is reproduced below. This is provided for educational purposes only and is not intended to be legal advice. Understanding the California foreclosure process timeline is key to getting perspective on your situation and options. Many homeowners will receive one of the notices mentioned in this article and either ignore it or misinterpret the meaning. In today's post, we will break down exactly the way California foreclosures unfold, so that you can arm yourself with knowledge of your rights as a property owner. Step 1. Notice of Default. The Notice of Default, NOD, is the first step on the part of the lender to initiate foreclosure actions. The Notice of Default in California is recorded once the borrower fails to meet the agreed-upon terms of the loan. Typically, this simply means missing a payment, although in practice the NOD period extends for 90 days before the lender officially moves to the next step in the process. At this point, the property is considered to be in pre-foreclosure, and the homeowner may receive a notice through the mail with a projected sale date. Step 2. Notice of Trustee Sale. As soon as 90 days have passed from the NOD being recorded, the lender can then issue a Notice of Trustee Sale. Unlike the NOD, which is essentially a courtesy window to allow the borrower to become current, the notice of sale in California is an actionable notice. It serves as a declaration of intent to sell the property at auction right out from under the homeowner. Step 3. Auction. Depending on a variety of factors, the actual auction date for the property can vary widely. Technically, however, the lender/trustee only needs to wait 20 days after the notice of trustee sale has been issued. However, there are several ways to postpone the actual auction, and many homeowners don't face their actual sale date for about a year after the initial date. Step 4. Aftermath. There are 4 main outcomes that can follow the auction phase of the foreclosure process: postponement, cancellation, sale to bank, and sale to third party. Let's look at each of these outcomes and what they mean for the property owner. Postponement. If you are able to secure a postponement, usually with the help of a foreclosure attorney, a new auction date is set and the process starts all over again. A postponement can be sought for a number of reasons: to simply buy more time in the property before moving, to give yourself more time to restore your finances and become current, or to prolong the window for formulating a legal strategy to fight against the foreclosure. Cancellation. There are several reasons why an auction sale can be canceled entirely. For example, the owner may decide to initiate a short sale of the property. Perhaps a loan modification was agreed upon at the last minute. At any rate, a cancellation is typically good news for the homeowner, but it doesn't necessarily mean that they get to keep the property when all is said and done. Sale to bank. A frequent outcome of the auction sale is that the lender is the only one to bid on the property. Often, the home will go right back into the lender's possession. In this instance, it is sometimes possible to regain title after the sale, usually with the help of an aggressive and experienced foreclosure attorney. Sell to third party. Properties in foreclosure are often attractive to third-party buyers who seek to capitalize on the distressed nature of the property in order to get a good deal. In these cases, it is usually impossible to regain title to the home, despite the third party needing to follow rigid guidelines regarding treatment of the previous owners. Depending on where you are in the California foreclosure process, different options and outcomes may be more attractive to you than others. As always, it is best to consult with a qualified and experienced California-based foreclosure attorney in order to assess the proper course of action for your own unique situation. End of page.